Climate advocacy would be utterly discouraging if it was always made to some apocalyptic and hopeless tune. Perhaps this is why climate and environmental advocates and activists celebrate to the fullest whenever progress is realized and milestones are reached. Within a week after the International Court of Justice, ICJ advisory opinion on environmental harm was announced, some have expressed their doubts about its efficacy and warned the region not to be too quick to celebrate. When asked what sore points he identified in the advisory opinion of the 23rd of July, this is what Dr. James Fletcher had to say.
I listened to the opinion being read out live yesterday, and I just kept saying, okay. Wow, okay, so that we're actually getting everything, and we're getting it in a very forceful manner, not a timid manner that, okay, yes, they've caused harm, but no, there's nothing they can do about it. No, you can't really attribute harm to it. It's saying no, you have to use the science, and even when there's uncertainty, you cannot not do something because you're not quite sure what's the cause or who's causing it. So the whole precautionary principle was brought into play.
He was especially impressed with the advisory opinion's position on liability and reparations.
It wasn't a timid advisory opinion. It was an advisory opinion that basically said that states are responsible for the harm that they're causing, and they have a right to do something. They have a responsibility to do something, and we also have a right to measures that would either cause them to stop it, not repeat it, or provide us with some sort of reparations as a result of what they're doing. So that also brings into play the whole question of climate finance, which we've been calling for. And the developed countries almost make it look as if it's charity, that it's not something that they have to give to us. Well, the court is saying no, you have to, because you've caused the harm and you have a responsibility to repair that harm. So it really was a groundbreaking advisory opinion.
Dr. Fletcher has advocated that in addition to the painstakingly incremental method of moral suasion by international agreements meant to address climate change, the greenhouse gas emissions and other environmental harms must also be addressed through litigation. He drew a parallel to the tobacco industry's scrutiny and outright denial of scientific evidence that smoking causes illness and death, as opposed to the change that was brought about in the industry as a result of class action lawsuits against tobacco companies.
I maintain that the same thing has to happen within the fossil fuel sector, because despite everything that countries have committed to, the fossil fuel industry is still being subsidized to the tune of trillions of dollars. So yes, they've said, yeah, we'll do what we have to do, we'll decarbonize, but they're not. Emissions are still growing. So the only way you could get them to stop doing what they're doing, or to slow down to the point where at least we don't have to worry about stronger hurricanes, longer droughts, heavier flooding, acidic oceans, is when you force them to start paying for the damages that they've caused. So this is why this ruling, this advisory opinion is such an important one, because it now lays the foundation for new jurisprudence on climate. That this is something that national courts can now look back on, both this and the ruling by the Inter-American Court, and say, well, look, no, this advisory opinion gives us the basis because this is what it sets out. So although the advisory opinion is not law, but it is something from which law will now derive and which new law will be created.
This struggle can be an uphill battle, particularly because fighters against climate change find themselves opposed on some level to industrialization and its environmental impacts. The fact that the war is still ongoing is no reason not to celebrate the victories seen along the way. For Choice News Now, I am Cinna Dalsan.